Good evening. This is Laws 11057, Introduction to Law. It's week number 4. And tonight we're dealing with a number of issues. It's a big night. And please feel free to join in with any questions through the chat facility or ask live. Prior to starting the recording, I just reminded people that at week 12, I'd like to challenge whoever is the fastest typist in the class to a typing test. And I use the word typing loosely because I use Dragon. All right, research skills. I did warn you at the start that we're going to try and cover everything at the one time. It's very hard to prioritise, so let's talk about research skills tonight. There are some basic skills. I'm referring to the new lawyer, and also, of course, we have the text on legal research. But tonight, first up, the new lawyer, Chapter 6. There are some basic skills which are referred to in page 192 of the text. In essence, take a systematic approach to your research, but know where to find some of the important issues. So one of the research questions for this week was try and find the Australian consumer law and try and find the criminal code. One of the reasons I chose those is that they're not pieces of legislation per se, but they are important documents which are referred to in schedules to legislation. So much so that the actual schedule in those two instances is in real terms far more important than the Act itself. So hopefully you've done that exercise. We might talk more about that later. And the important point is that you get a start to feel for how to do your legal research. One thing you'll hear me say often is go to the primary resources first and then go to the secondary resources. I didn't do that for a long time, but now I trust myself, I guess, a bit more, and I'd urge you to start trusting yourself in terms of your ability. So don't read necessarily first up what someone says about the law. Go straight to the law. Go to the legislation. Go to the cases, and then perhaps refer to the secondary sources after that. So it is important that you have good quality information. LexisNexis, Thomson Reuters, CCH, and then of course you have the authorised services, the Office of Queensland Parliamentary Counsel. You'd access that through Queensland courts, ComLaw for legislation at the Commonwealth level, and the unauthorised but still excellent Ostly, which I use very regularly. You need to read actively and efficiently. You need to pace your reading. Don't read in law, don't read at the one pace. You'll get bogged down. So you need to learn processes of speed reading. I will give you some hints in that regard about the way that I selectively highlight. I might be able to just show you what I mean. So I've just selected a page at random, and you'll see there that I've highlighted some yellow text. The important point about that yellow text is that if you just read the yellow bits, it will make sense as a sentence. And I think that's very important, so that you're not having to necessarily rethink what the concept is. When you come back to your revision, you can read the yellow parts and get an idea of what it all means. So you need to be able to, in a sense, speed read, but you do work at two speeds. You may need to peruse, and peruse means to carefully read or carefully consider. So sometimes, depending on the circumstances, once you've narrowed in and you've determined what it is that you're after, you may need to read very slowly and perhaps a number of times. All right, so plan your research, identify the task, and this is not always that obvious. You see, the task might be for you to draft a contract, or it might be to draft a deed, or an opinion, or some pleadings, or it might be a combination of both, or some of those things. Also, and this can be difficult too, identify the specific area of law or laws. Now, when you're studying contract law, you'd expect that everything is to do with contract, same with torts or criminal law, etc. But in practice, in reality, all of these things get merged in at once. So a single issue may in fact relate partly to contract, partly to torts, partly to Australian consumer law, or it may even be constitutional law or criminal law. So as you're as you progress in your studies, you'll need to think less in a compartmentalized fashion and think more broadly. Be wary of considering practice only in the context of one particular domain. And I may have said before that conveyancers are very hardworking, very knowledgeable, but just sometimes they tend to think only in their specific area of practice. So be careful of that, and we all do. I pick on the conveyancers, but we all do that to some degree. What that means is that sometimes you need to work out a technique to determine what are the appropriate areas of law, and I use the term brainstorming a lot. What I mean by that is just taking a moment to really think about all sorts of options that may come up. Might seem silly, you might be able to dismiss them straight away. But if you actually go through and verbalise that or work in a team, just throw up any ideas. Or, if you've got a criminal law matter where someone is being prosecuted, then maybe it's not so silly to think about going back to, let's say, the Administrative Appeals Tribunal to see if you can overturn the original decision which led to the ultimate prosecution. So to just think about different options. Now, that, of course, that example is only very specific in certain circumstances, but it gives you an idea of what I mean by this term brainstorming. All right, there's no questions yet, no comments. Well, I'll keep going. As I said, there's a lot to consider tonight, so hopefully I won't be going too fast. Now, for those of you that are intending to practice in law, and as you know, that's the focus of this course, those that wish to practice in law, you must be very careful to consider your legal research in the context of the timeframes, the cost, and the consequences. Now, if you're employed in a law firm in private practice, these things are vitally important. You're really not going to help yourself or your employer or your client if you work through the night on a single issue in relation to a case where there might be 10 issues and the matter has to be considered by a court the next day. You might think, I'm working very hard, I've done all this overtime, but in reality, you haven't been able to consider the whole consequence or the whole picture in terms of the legal research or the work that you've undertaken. So think about the time, think about the cost associated with the work that you're doing, and think about the consequences of what you're trying to do. It's not easy, and it takes some talent to do. And of course, the more experienced you become, the quicker you can get at these things. So it is tough when you're starting out. I accept that. All right, so legal research, a bit more specific. Don't forget you have the Boolean connectors. So if you're looking at some research, type in the word say, director's duties, and capital A, capital N, capital D, so all caps, and duty of care. And by using that capitalization of the connector "an," you are using it as a Boolean connector, and it means that in your legal research, the online format or program will provide you with information which combines those two phrases in circumstances where they were described closely in a case. Right? Does anyone use Boolean connectors? Have you found that to be an easy way to study, to do your research? Is anyone looking at me completely blankly? Yes, awesome, says Rowan. That's good. I'm just going to, if you're a bit shy, just duck away because I'm just going to put you on gallery view so we can see who's there. All right, we've got, lots of people are showing their faces. That's great. All right, so just as a hands up, are we using Boolean connectors? Just give me a show of hands. Yes? All right. And if you haven't been using it, I'm sure that you will try that, hopefully tonight or tomorrow. Okay. Kind of. All right. I'm a bit like you, Jonathan. I use them kind of as well. Primary sources, legislation and case law. Secondary sources, commentaries. I've talked about that, where I'd like you to go. Important reference points, say the Australian Consumer Law or Criminal Code. I take it everyone will know now how to find those things. And be careful about spending an enormous amount of time in wasted research. So there's that speed versus accuracy paradigm that needs to be considered. When it gets to the detailed reading, you might need to read and reread. And very importantly, watch out for special words such as unless or not, things that will change the context immediately and dramatically. And it's easy to overlook that. It's easy to gloss over it and say, I didn't see that word unless, or in certain circumstances, or whatever it might be. All right, now, all of you are having some fun with referencing. I know that. I can see that in the excellent discussions that are going on through UCrew. Those of you that are embracing UCrew, good on you. And there are many of you. You're helping each other and you're helping yourself at the same time. If you're not involved in UCrew, please get on board. You'll find it a very valuable way to exchange information, interact, and create a collegiate approach to your studies. Also, many of you would that have sent me an email with a question or a message asking for a response. I provided the answer, but also a very clear request. Please ask these sorts of questions through UCrew, because I'm just one person, and there's 100 of you out there, and you've all got excellent ideas, and many times students are able to provide assistance to each other, which I wouldn't necessarily be able to provide. So it's a learning exercise for me as well, particularly in terms of technology. Some of the things that students have come up with have helped me greatly, so I know they would help others doing the course. So with UCrew, thank you very much for doing that. Now, there have been these discussions about citing your research. Don't get too concerned about it. People are making some genuine attempts. I'm looking forward to reading the assignments. I haven't read any of them yet. The close is 11:45 p.m. tomorrow. Please try to submit your work on time, otherwise you will have the penalty which is imposed. And of course, you must have all your assignments in by, I think the cutoff is Saturday of next week. So you've got about 8 or 9 days to submit your work. If it's not in by the final cutoff, then it will be a 0. All right, but I think I've explained that before. And for those of you that have already submitted your work, good on you. That's great. All right, so footnotes, it's not really it's not a difficult thing to do. You just go into references, insert footnote, it takes you down. I usually tab away from the number. You would have seen that in my sample document, but it's really quite simple. Where it gets a bit technical is when you're referring to a case, I'd prefer that you directed me to a specific paragraph or page, usually a page in the case. Try not to just simply say, that there are 13 references all saying Humsey Hancock. Be more specific than that. And there are different ways of pinpoint referencing. One, for example, is say Dietrich v. R or against R, open bracket 1992, close brackets 177 CLR 292, 299. That's one way of saying go to page 299 in the case. Or another way of doing is to say at page 299, which is what I generally do and prefer. You may have picked up a few things. When you're referring to case law and legislation, please do so by printing the relevant parts in italics. Does everyone understand that? All right, so if you're referring to a piece of legislation, then you will name the legislation in italics, and the year that the act was passed is part of the italicized part. If you're referring to a case, you will italicize the names of the parties, but you won't italicize the reference. I'll just put you on gallery view. Does everyone understand that? Can I just have a show of hands? Has everyone got an idea of what I mean by that? Yes? I'm getting a lot of thumbs up. Okay, that's good. That's good. It is one of my little pet hates not to see things italicized when they should be. Having said that, I know that it is really frustrating when you read what I put in UCrew, that legislation and case law is not italicized, and that's because I haven't yet worked out, as good as UCrew is, I haven't worked out how to make those sorts of formatting changes. So I'll be keen to learn more, and I'll be watching what others do. All right. So there's a question. I didn't do it this time. Does it matter? No, it's fine. You're not going to get marked down on this occasion. But just from now on, I'm really keen on it. And have a look at the sample document that I prepared, because there's a lot of hints in there as well. If you're referring to a case, if it's just by the year, then the year will be in square brackets. If it's a case which is referred to by year and volume, then the year will be in round brackets, followed by the volume number. This is all a bit artificial and it's a bit old-fashioned. I'll just explain. Of course, back in the old days, back in the 70s when I was studying, we didn't have computers at all. So everything was in a book, and these books were divided into years, and sometimes they were divided into volumes. So there were these different things that were created and have still endured into the future. All right, so don't include the URL when you're referring to a case. What I'm really interested in is its official citation, rather than the URL link. Have a look at examples on page 256 and 257 of the new lawyer. I've made a note to myself. So let's have a look at that now, if you've got your text with you. Right, yes. On page 256 at the bottom, you'll see some excellent examples of how to reference legislation. Lots of references to the very important Acts Interpretation Acts, Commonwealth and State. And on page 257, you'll see some reference to, yes, the footnote. On footnote number 38, you'll see an excellent way of referring to a pinpoint reference in a case. In this instance, the authors have used the technique of the comma. So the case started at page 252, but the pinpoint reference is at 262. Any questions about that? And you can see that's an example of what I keep saying. If you're starting to be unsure about how to reference, just have a look at how good authors and judges do that. It'll make it easier and you'll start to pick it up. Right, are there any questions? No questions at this stage. Nothing on the chat line. Nobody wants to ask a question live. All right. I have a note. I'm doing this by section. Yes, that might be a way to do things as well. Thank you, Dinah. All right, so be reluctant. AGLC, says Rowan, says use a space before the number and after the comma. Yeah, we are following the Australian Guide to Legal Citations. Are there any issues about that? All right, so there's a question. Microphone doesn't work, but with referencing, says Tiffany, should we place a comma between the paragraph numbers? If that question is designed to ask the question about what it's like, say, on the bottom of page 257, then the answer would be yes. Like it's done on page 38 of the new lawyer. So Tiffany is just asking us to refer to page 38 of the new lawyer. So we'll quickly do that. Pity microphone's not working. Oh no, sorry. I meant page 257. Okay, we'll go back to 257. Yes, that's it. The bottom of page 257, you'll see the comma. So that's a very good way of doing things. All right. At page 16 of, this is the first time I've really referred to it, Practical Guide to Legal Research, there is a comment made, which I think is excellent, and I made a note to myself to refer you to this. It's at page 16 and it says, there are legal implications aligned to so many so-called simple facts. The reason I wanted to raise that issue is simply this, that you must be careful about immediately jumping to a conclusion. There may be other issues which should be considered in the context of the matter that you're dealing with. I'll give a conveyancing example. For those of you that are new to law, this is probably a bit technical. Don't worry, it's not meant to be examinable, this example. But the conveyancers might be aware of a thing called a caveat. A caveat's a document which is lodged on a title, and it has the effect of stopping any dealings with that particular title or that property without reference back to the person who lodged the caveat. It'll lapse after a period of time, 3 months or so, if you don't do anything about it, but effectively it stops. So if you have a case where someone has signed a contract and they've lodged a caveat to support their claim that nothing should happen while that contract is in existence, question might be asked, for example, can the other side remove that caveat? Now, the simple answer is no, of course not. The person who signed the contract to purchase the property has a caveatable interest, therefore they're entitled to lodge a caveat. The other side can't complain about that. However, there may be more to the story. It may be that the purchaser signed the contract in circumstances where it can be argued it was unconscionable conduct or through fraud or some other means. So there might be another argument to it. It's not just a matter of simply saying, yes, you have a caveatable interest, therefore you can lodge a caveat, and that's the end of the matter. Okay? So just watch out for that, and that's why I wanted to raise that point. If there are no questions, I'll keep moving. Sorry, there's a lot tonight. Chapter 7, Interpretation Skills, pages 227 to 264. We're dealing with the methods used by lawyers to interpret legislation, case law, which is precedent, and other documents. So let's now talk about statutory interpretation. Many of you will cover statutory interpretation in an entirely separate course, so I will be brief. There will not be a question per se in relation to statutory interpretation. However, there is a drafting exercise which will be in the examination. You know that already. I'll talk more about that tonight. And the techniques that we use in statutory interpretation, you might find useful in the context of drafting generally, as well as being of general relevance to your examination. All right, so some of the different approaches to statutory interpretation. The literal approach. I'm just putting everyone on speaker view, just to warn you. On grid view. Has anyone come across this literal approach? How would lawyers use the literal approach to support an argument? Any ideas? All right, so lawyers often try to exploit loopholes, don't they? So they might say, well, yes, but if you read this piece of legislation strictly and literally, it might mean this. So it's the literal meaning of words that are used, words as they mean in common talk, the words are taken literally, the words mean what they literally say. All right, so lots of answers coming through. Thank you very much for that. The example in the text is very good, where it makes reference to penalties imposed for speeding between, but not exactly on, certain speeds. And the argument there, well, I wasn't driving between 0 and 10 over the limit, or between 10 and 20 over the limit. I was driving at exactly 10 over the limit. Therefore, if you look at the way in which the wording of the penalty act was imposed, I should be free of any penalty. So that's a very literal approach where you're trying to take a loophole. That literal approach is modified by the golden rule. So if the reading of the statute results in what might be regarded as an absurd result, then the court would normally modify the literal meaning to avoid that absurdity. And I'm sure you've all read this in the book, so I'll just be brief. The contextual approach is look at the words in the context where they're found. So in the book, spectators are prohibited from taking glasses into the seating area. Well, we're not talking about reading glasses, are we? If we look at that in context, we know that that means something, glasses for drinking. The purposive approach, the court will have regard to the apparent purpose of the legislation. Now, this is important. Do consider the implications, or do consider the Acts Interpretation Acts, both Commonwealth, which is 1901, and State, which is 1954. So at various times you will find that specific words or concepts may be defined in the legislation that you're dealing with, or you may have to go to the Acts Interpretation Act to determine what's actually meant. So, I mean, for example, and I don't know if this is in there, but it wouldn't surprise me. Things like a business day. What's meant by a business day? You might look in the legislation, say the Property Law Act. If it's not there, don't forget to go and have a look in the Acts Interpretation Act, because it might be there as well. Now, there may be some issues to do with separation of powers when one considers the purposive test or approach. The courts might be said as intruding into the area of policy by trying to interpret the purpose behind what Parliament said. Alternatively, through the Acts Interpretation Act, it may be seen as Parliament attempting to intrude into the realm of the judiciary by interpreting legislation. Now, you should all be listening very carefully if I mention that phrase, separation of powers. Did everyone understand what I was getting at there? And I know it's quick. So just have a think about your reading and the purposive approach, and try to ask yourself, how is that potentially infringing the rule about separation of powers both ways? The courts intruding into Parliament, the Parliament intruding into the courts. It may be or maybe not. All right, let's move on. Common law presumptions. Can you hear me now properly? I was breaking up, sorry. There are some common law presumptions that's in the text, and there are some statutory rules. So the common law presumptions, have a look at page 250 of your text, and there are a few that I'd like to highlight. Number one, words have their current meaning. So, for example, television broadcasting wasn't considered when the Commonwealth Constitution was prepared, but in Jones against the Commonwealth, the High Court held that broadcasting should in fact be a Commonwealth power, or within the Commonwealth power, because it fits within the dealings with postal, telegraphic, telephonic and other like services. Number two, words have their technical meaning. So in law, certain words have a specific meaning as opposed to the general sense. So in contract law, we talk about a contract being frustrated. Nothing to do with frustration as we normally understand it, but it has a particular technical meaning. So at common law, there's a presumption that if in a statute there's a particular word meaning, which has both meaning, then the technical meaning is what is meant by Parliament. Number 13, things not included are excluded. Well, what does that mean? The example in the text is a road sign that says that parking is not prohibited at certain times, then by implication parking is permitted at other times. The only difficulty with that common law presumption is that it does provide some justification for wordiness in drafting, which is to be avoided if possible. Number 15, Later provisions override earlier provisions. So a later law is presumed to override and therefore automatically repeal an earlier law to the extent of the inconsistency being an earlier law on the same topic. Okay. Are there any questions? I don't like this time of year. Allergies spring up. Anyone else have problems with allergies, or is it just me? Everything becomes harder this time of year. Hay fever, yes, it drives me crazy. All right, statutory rules. As mentioned a couple of times tonight, make sure you consider the Acts Interpretation Act. All right, so we've talked so far about, in Chapter 7, the way in which statutes are interpreted, the way in which cases are interpreted, some common law presumptions. Also, there's the issue of how to interpret a contract. Now, did anyone read about the Clapham Omnibus and the man on it? You don't know what I'm talking about, do you? The reasonable man test. Does anyone know what I'm talking about? It was in my sample document. Yes? Not this year. Said Rowan. Objective test. Yes, Kimberly. Thank you, Jonathan. Objective test. Good. That's what I'm after. So what is this objective test? And what is it opposed to? So what's the opposite of the objective test? I'm looking for some answers here. Subjective. Yes. Subjective. Subjective. That's it. We got it. All right. So what's an objective test mean? Well, essentially what a reasonable person might think, looking from the outside. So in the context of contract interpretation, if there's a dispute, if there's an ambiguity, by an objective test, a court would interpret from the perspective of what a reasonable person would think the term means. So what was actually intended is not taken into consideration. If the court is called upon to interpret the terms of a written contract, then the court, as a general rule, considers only what is written and will not consider any prior or contemporaneous verbal exchanges. We call that the parole evidence rule, parole evidence. Kind of important in practice. If you're dealing in contract law, you really need to be aware of this, because something might be important, but if it's not included in the contract, the other side might say, well, the parole evidence rule will preclude you from leading evidence in relation to something. And you don't want that. So the important point there is try to ensure that the written contract is in fact a complete record of the agreement. All right, there's some comments in page 260 about uncertainty. I'll leave you to read that. And the use of the objective test, the officious bystander, as it's called. All right, let's get on to something absolutely, definitely linked to the examination. It's the issue of redrafting skills. I'm going to try something here. I hope this works. And that is to share my screen with you. So please bear with me while I do this, and hopefully it will work. Now, are we all seeing my screen with a page on it? If you just give me a thumbs up or a note. We are? All right. Okay, and you can see Lovely's Windows 10 has arrived on my desktop, which is pretty good. Okay, so redrafting. If you look at page 237 of the text and read the commentary from the English case decided in 1979, it will give you an idea of the drafting techniques back in the 70s when I was studying and when I started to practice. And that was really quite common. So that's on page 237. And that's exactly what we want to avoid now. And that's why I'm very keen on speaking with you about drafting techniques. So did you all see that on page 237? It's a quote from a case in England from the All England reports. I won't read it, it's just too dull, but it's really hard to read. And also, can you see how in the draft person, probably a man at that stage, because there weren't that many women practicing, which is silly. But anyway, that's the way it was. It's not now, which is good. You can see that they've tried to describe everything ad nauseum. It's just really terrible drafting technique. So in the examination for term 2 last year, students were asked to rewrite this nonsense. And typically it was about 400 words that I'll use, and you have to write it in 100 words. Can someone give me some idea of what we've learnt so far as a technique that might assist you in challenging that question? All right, so that's the question that we had to redraft. Just let's brainstorm. Give me some ideas on how you would go about it. Trying to second guess the literal interpretation? Yes. All right, so material facts. Oh, I like that term. Material facts. Yep, a couple have come in with that. Yep. All right, so what's a technique for looking at the facts? Yes. What's a technique? If you're in an exam, if I were you, I'd take in one of these highlighters. You probably can't see me now because my screen's not there, but I just had a yellow highlighter in my hand. And I would probably try and identify the material facts as I went. So you might think that that's a material fact. Every student. What else is another thing? Enrolled at this university. Okay, we might think, well, that's probably important. Being a tertiary education establishment, is that important? We all know that university is a tertiary establishment, so forget that. That's garbage. Independent in its function from the operation of activities from other universities, well, that's garbage too, isn't it? All right, so you're getting an idea of trying to identify the important words. Engaged in unpaid employment and volunteer work, blah, blah, blah. No, there's just so much garbage there. All right, so ultimately, as a guide to the answer, and I came up with 101 words, despite the fact that I say don't use dot points, what did I do here? I use dot points. Can you see this screen? Is it too small? You can all see it? Okay, good. All right, so what I've said there, every student who is enrolled in the university or this tertiary establishment shall at various times be subject to the ethical standards imposed by the university. Any student found guilty of behaviour contradict the standards may be disciplined. A disciplinary committee may be appointed and the student will be notified as to the date of hearing. University reserves the right to investigate the matter comprehensively and they may seek legal advice. Now that's what I came up with. Other students came up with things were just as good, probably better than that, but that was my answer guide to myself. All right, so any questions about the nature of that redrafting exercise and perhaps a sample way of dealing with the issue? Everyone fine? I'm just going to go to gallery view to see if everyone's awake. We're all still there. That's excellent. All right, good. Okay. Are there any questions about that redrafting exercise? We're all fine with that? Okay. Let's move on then. Research, Barnet, Jade. Now, is anyone using Barnet at the moment? Has anyone? Yes, we've got a few hands are going up. It's excellent. Has anyone registered and is actually starting to receive cases by email? Yes, we've got a few. Oh, that's good. Oh, lots. Everyone is. That's great. I'm really pleased to hear that. Ah, very good. Has it been a pain or has it been helpful? Are people happy with it? Is it good or bad? Helpful? Helpful, good. Okay. All right, that's good. I think it's great because you want to be part of this profession right now. You want to see yourself as being a practitioner. You want to see yourself at the cutting edge. You've got a great advantage. You're starting out, so you're seeing everything fresh. People that are already in practice, they're way behind you. So you've got a big advantage, don't you think? All right. So you're seeing all the latest cases. So I can be really impressed, and other course coordinators can be very impressed by that fact. All right. So there are a few ways to deal with Barnet. You can use the Search Now facility. Actually, I'll put this across. I'll share the screen again. You can see that now. Share the screen. All right. So Barnet Jade, use the Search Now facility at the top of the page. Select a case. In the top right-hand corner, you'll see Jade Case Trace. Go to Litigation History. That's one way to do the search function. Another thing you can do is register by going to My Jade. You can create the alerts. You've already done that, most of you. And you can change the alerts through Jade as well. All right. So in problem 19, in the text is, look at Jade Barnet and identify what it's all about, how it can be used, and how you register. So many of you will find that very easy. The next thing is Ostly database search. I think you're all using Ostly. Can I just get a quick indication? Are we using Ostly? We know about the node up function. Yes? All right, that's good. That's good. And this is why it's important you go to these places first, I think, and then LexisNexis. So that's excellent as well. Go to the General tab, insert a name such as Marbo. And then, of course, we had problem number 9, which dealt with the issue of section 549 of the text. And that's really got some... that was a good exercise, I think, in that, and you're just on gallery view again. What I wanted you to do is get a feel for how you're going to start to research in practice, use the Node Up facility, find some of these more obscure things like the criminal code and the Australian consumer law. Not that they're obscure in practice, they're far from it, but just a little bit obscure to find them, that's all. Did anyone have any difficulty with this exercise? Or was it pretty simple at the end of the day? All right. I'm just looking for some responses. Yeah, was it simple? Yes, simple? Yep, lots of thumbs up. Okay. Excellent. All right, well, we're running out of time. That's probably all for this week. One says, haven't done it yet, but do that exercise. It's really important. I really do want you to have a go at that. That's problem number 9, I believe, in your material. Okay, so thanks to all of you who have already submitted your paper. If you haven't, work on it tonight. Have fun with it. Don't get bogged down. It's not that serious. All right? It is, but it isn't, if you know what I mean. The world's not going to change if you make a mistake. It's no big deal. All right? So give it a go. Okay. Well, thank you very much for your attendance. Before I finish, are there any questions? Anybody want to ask a question live? Unmute your microphone if you do. All right. Well, thank you. I'll stop the recording now. Oh, there was a question? No.